On Wednesday, February 7th, the Federal High Court sitting in Lagos ordered the federal government of Nigeria to fix the prices of goods and petroleum products within 7 days from that day. Justice Louis Alagwa granted the order at the instance of Senior Advocate of Nigeria, Femi Falana, who sued the respondents, the Price Control Board, and the Attorney General of the Federation before the court. The judge held that despite the service of the court processes on the respondents, there was no opposition to it by way of a counter affidavit, which in law means that all the facts as stated by Falana were deemed admitted. Falana had said, among other things, that the price of a bag of rice, which was formerly 8,000 naira, has risen to 45,000 naira in the market, and that the situation in the market is with each passing day becoming more unbearable for consumers as prices of goods keeps rising on a daily basis. The judge then ordered the Nigerian government to fix the price of milk, flour, salt, sugar, bicycles and its spare parts, matches, motorcycles and its spare parts, motor vehicles and its spare parts, as well as petroleum products, which include diesel, petroleum, motor spirits, PMS, and kerosene. I caught up with Mr. Falana in his Lagos office to examine the court's decision in more detail. I began by asking him the question which had become a serious talking point online and especially among the legal community. Is this order enforceable?
For sure. This law has been with us since 1977. There were moments when the government had enforced the law. People were convicted, people were jailed for selling goods beyond the fixed prices. And in any case, there is a price control board in Abuja, which is supposed to have branches in all the states of the Federation. We also have the Federal Consumer Protection Commission, again, to monitor prices of goods and ensure that consumers are not exploited. So I didn't make both laws. All we did was just to dust off these laws and approach the court to protect consumers, particularly the poor and the vulnerable. The Bola Tinubu administration has said that there is food in abundance in Nigeria. At least, I think the Minister of Information made that statement a couple of days ago. But we have a situation where majority of our people cannot afford the prices that have gone to the roof. And so that is why the government has a duty under the law, under the Price Control Act, to control the prices of essential commodities so that Nigerians will not be subjected to hunger unnecessarily. It's so bad now that if you go to the market today and you pick up a food item, if you go back to the same market tomorrow, the price has gone up. And you cannot allow that, So the law is there. The law is enforceable, and the government is enforcing. In some selected areas, the government is enforcing.
But the arguments by business analysts that Nigeria runs a capitalist system where individuals and even lawyers like yourselves are free to fix their prices and fees, since government does not control the means of production.
Unfortunately, people are not aware that by virtue of Section 16 of the Nigerian Constitution, the government shall control the economy in a way, in a manner that there is prosperity in our country. Prosperity for the people. Happiness for the people. Not for the elite. Not for the bourgeoisie. Now, let us come to specifics. Most Nigerians today, most businesses are run on generators because of the failure of the government to supply energy in the country. But what is important is that by virtue of Section 16 of the Nigerian Constitution, the government has a duty to promote the happiness of our people, to plan the economy in a way that the Commonwealth is not concentrated in the hands of a few people or a group. Some captains of industry, you call them captains of industry. In 5 years, under the Buhari administration, we are granted duty waivers to the tune of 16 trillion naira. So if you do not allow them to pay duties in order to supply goods to Nigerians, the government cannot say, sorry, we're not going to control your prices. So because the duty waivers, the duty that should have been collected and put in the Federation account for collective good is cornered. Those duties are cornered by a few people. That's not capitalism. That's monopoly. And so because the government wants to encourage some businesses, we are granting duty waivers, then the government must also protect the people from exploitation by those who are benefited from the system. The goods being brought to the country without payment of duties will have to be monitored and supervised and controlled by the government. And if you don't want to be controlled, bring your goods and pay duties, appropriate duties, and then charge whatever you decide. But there's no way you can be allowed by the law to benefit maximally from the system, and then you go to the market to fix any price you like. So, and that is the whole essence of this case.
I hear what you say, Leonard Silk, but what would you say to the arguments made in some quarters that this order suggests that the country should reintroduce subsidy on petroleum products and even extend it to consumer goods?
I am saying subsidies are introduced every day. And in every country in the world, including leading capitalist society countries, goods are subsidized. And I'm saying the rich are subsidized in Nigeria. You ask them not to pay duties. You go to the Niger Delta, part of the country. You take the oil resources, right? Because the Constitution, Section 44, subsection 3, provides that all mineral resources in Nigeria shall be acquired by the government and managed on behalf of the Nigerian people. Having acquired the oil resources in the Niger Delta, the government sits down in Abuja and gives oil blocks to some individuals who, without investing a dime, become instant billionaires by simply hawking the licenses. So this system subsidizes the rich. They are given tax holidays, duty waivers, and you are saying whatever is produced there, the government should have no say? No. That would be subversive of our sovereignty. Because the system shall be managed, the economy shall be managed and operated in such a manner that the wealth of the country is not concentrated in the hands of a few or a group. And the only way you can do that is for the government to intervene decisively on behalf of the majority of our people. This is the essence of the Price Control Act, by the way. More so that the government is saying that, the government is insisting that there's abundance of food in Nigeria. So, therefore, the government must intervene and ensure that the people have access to such food items. problems. Because people are already dying of hunger, kwashiorkor, or children. And people are forced to come out now. People are protesting. And the earlier the government moves speedily to arrest the ugly development, the country may be sitting on a keg of gunpowder. And I hope the government will realize that a hungry person, a hungry man, is an angry man.
And they should stop playing politics.
So the earlier will accept the reality and address the problem, the dollarization of the economy will have to be addressed by the government. The floating of the currency will have to be reviewed by the government. The removal of subsidy, fuel subsidy, will have to be considered by the government. Because these are the problems.
Let me bring you back to the law. I've heard some lawyers and even some other people say that the Price Control Act is moribund and it's mostly a carryover of our inglorious military past.
You know, unfortunately, some of my colleagues, because of their ideological background, cannot appreciate the duty of a government. It's a bit selfish on the part of the elite. It's only when it comes to the poor that we are talking of the impracticalities. Oh, it's impossible to enforce the judgment. When a court says, go and educate every Nigerian child. Oh, how is that possible? Where will the government get the money? When the government rules that everybody is entitled to basic health care, our colleagues say, oh, how will government fund it? In the same country, an individual was alleged to have stolen over 100 billion naira. Heavens have not collapsed. And you know what 100 billion naira would do to the economy of Nigeria today? And you can go on and on. So those who are saying that it's impossible to help the poor should be prepared for a war against exploitation. So we must avoid anarchy and chaos. And you can only do that by attaching importance to judgments of this nature. And for lawyers to find out how can we enforce this judgment, and not to say it is not possible to enforce this judgment.
So what next after 7 days if the government fails or refuses to enforce the order?
We have applied for the certified true copy of the order. We'll serve it on the government. And after 7 days, we'll take appropriate action under the law. But I'm aware that the government is going to be compelled to speak up. The report of the Auditor General of the Federation, submitted to the National Assembly in 2020, and on which no action was taken. Some of the revelations include the fact, two of the revelations include the fact that $4 billion yanked off from the foreign reserves of Nigeria cannot be located. And $3.5 billion loan taken from the IMF was stolen by yet to be identified individuals. And I'm talking of $7.5 billion. The governor of the Central Bank, Mr. Cardoso, has also just disclosed that out of the $7 billion alleged indebtedness of the bank, $2.4 billion cannot be justified. I'm also surprised that my colleagues are not interested in the judgment of the Supreme Court on the economy. the most important judgment of the Supreme Court on the economy. The Supreme Court ruled that and ordered the government of Nigeria to collect outstanding royalties for royalties not collected from the oil majors. So the government has not enforced that judgment of collecting $62 billion from 6 international oil companies and from LNG, $34.5 billion. From the Auditor General's report, $7.5 billion. From the Central Bank, $2.4 billion. I hope the government will have the courage, the political will to collect these funds. And I do hope my colleagues will direct their attention elsewhere instead of saying that a judgment meant to help the poor cannot be enforced.
Thanks for staying tuned. Next, we turn our attention to technology and the Nigerian judiciary. Here's a special report on the challenges and solutions.
For a very long time, the Nigerian legal system, particularly the courts, have adopted the manual method of operation. Court processes are filed manually. This is against what is obtained internationally, where the process is done digitally. In the open courts, judges still handwrite the proceedings, and most of the courts are not connected to the internet. The proceedings of the court are not broadcast live to the public or recorded. However, the court uses public address system for the proceedings. Technology, especially information and communication technology, now plays a huge role in legal practice. It is becoming increasingly clear that technology is a requirement for an effective and efficient legal education and practice. Before now, our laws did not recognize electronically generated evidence, but with the Evidence Act 2011, that has changed. According to some legal minds, some of the factors responsible for the slow pace of integrating technology into Nigeria's judiciary includes funding.
I think one of the major challenges might be attributed to inadequate funding of the judiciary. Because when you're talking about technology, technological infrastructure now, you need a lot of funds, to be able to achieve some of those things. So the questions we should be asking ourselves is that how well is the judiciary funded? That's one aspect of it. I think another aspect of it might also be that, a lot of our judges are used to, of course, long handwriting and maybe probably finding it very difficult to adjust to the reality on ground.
And all these things that you're looking into, but it goes beyond the judiciary itself, because the money is going to be made available by the executive. And after making it available, we have to ensure that the money is being spent on what those things are budgeted for.
Applying ICT in the judicial and legal process will increase efficiency, promote easy research, and allow for easier information retrieval, and in the long run, reduce stress and enhance the health of judicial officers. Ultimately, it will expedite the dispensation of justice.
When you look at it, when you weigh the advantages and the disadvantages of adopting technology in our proceedings far outweighs these disadvantages.
We pray that the Chief Justice of Nigeria and the various High Court Chief Justices will key into whatever comes on board to put that, because it helps early dispensation of justice. Because as the courts rise, the pace at which you are supposed to finish a case is delayed. The case that should be done in 5 minutes can take up to an hour because my lord is still writing in longhand. So now the National Assembly have done something wonderful by insisting that the funds of the judiciary should be increased. I pray this is utilized judiciously by the judiciary, that necessary infrastructures, particularly what you are saying now, will be on ground to assist the judge, because it's not rocket science. It's something that can be gotten and should be gotten.
A few courts already have some computers, and some judges have been trained in the integration of technology in the nation's judicial system. Stakeholders in the sector are hoping that the process is fully applied across all cadre of the nation's courts.
And just before we go, a quick recap of some of the top legal stories in the news.
We begin with the report that the Port Harcourt Division of the Rivers State High Court has renewed and extended the interim court order restraining the Nigerian police and other security agencies from arresting the Chief of Staff to the Rivers State Governor, Edison Ehie. The order was renewed by the trial judge, Justice Sika Aprioku, following a complaint by Mr. Ehie's lawyer, Senior Advocate of Nigeria, Damian Okoro, who informed the judge that despite the court's earlier order, the police had gone ahead to declare Edison wanted. After listening to the senior advocate, Justice Aprioku cited Order 4, Rule 4C of the Administration of Criminal Justice, which gives him power to renew or extend orders where applications are made ex parte. He extended the validity of the previous order till the substantive suit is determined. The judge then adjourned to the 15th of February 2024 for hearing of the substantive suit. Staying with the political crisis in Rivers State, the Federal High Court, Abuja, has rejected the bid by the alleged 5 loyalists of Governor Simlayi Fubara to challenge the jurisdiction of the court orally. They challenged the jurisdiction of the court on the grounds that the alleged offences are committed in Rivers State. The oral application was turned down by the court, which insisted all applications and motions must be brought before it in writing as required by law. Justice Olajuwon also turned down the request by the defendants to adjourn the case until their proposed application to challenge the jurisdiction of the court is determined one way or the other. The trial was subsequently adjourned till March the 12th, and the court ordered that all the defendants be returned to Kuje Prison in Abuja. In Lagos, the Federal High Court, sitting in Ikoyi, has struck out a 22.8 billion naira fraud charge against former Chief of Air Staff Air Marshal Adeshola Mosu and 2 other Air Force chiefs. Justice Chukwujeku Aneke set the military officers free while delivering rulings on their preliminary objections, challenging the court's jurisdiction to try them for the alleged crime. The court held that Amosu and his co-defendants, Air Vice Marshal Jacob Bola Adigun and Air Commodore Gbadebo Owodun Olugbenga, could not be tried by the Economic and Financial Crimes Commission EFCC because they were serving military officers at the time the alleged crime was committed. The EFCC accused them of conspiracy, stealing, money laundering, concealing of crime proceeds, and converting funds belonging to the Nigeria Air Force to their personal use around March the 5th, 2014 in Lagos. They, however, had pleaded not guilty to the charge. In Ogun State, the federal government has arraigned the governorship candidate of the People's Democratic Party (PDP) in the March 18 governorship election, Mr. Ladi Adebutu, on allegations of vote buying during the election. He was arraigned on a 7-count charge alongside 6 other suspects and accused of criminal inducement during the polls. The PDP candidate was also alleged to have ordered through his bank the issuance of 200,000 preloaded ATM Verve cards with 10,000 naira, which were distributed on the day of election across the state with criminal intention of inducing voters in the state. He, however, pleaded not guilty to the charge preferred against him. Presiding Judge Justice Abiodun Akiyemi granted the first defendant bail in the sum of 1 million naira with a surety in like sum who may be a family member or a bondsman. In Abuja, Justice James Omotosho of the Federal High Court has granted bail to the suspended Dean of the Faculty of Law, University of Calabar, Professor Cyril Ndifon, in the sum of 250 million naira in the sexual harassment and gratification case instituted against him by the Independent Corrupt Practices and Other Related Offences Commission. The court also granted his lawyer, Sonny Anyanwu, bail in the sum of 50 million naira, among other stringent bail conditions. Anyanwu, who is one of the lawyers in the defense, was joined in the amended charge filed on January the 22nd by the ICPC on the allegation that he called one of the prosecution witnesses on her mobile telephone during the pendency of the charge against Ndifong to threaten her. Both defendants are expected to produce two sureties who own properties within the FCT with a minimum valuation of 150 million naira and must submit their bank statements to the court. The court also held that defendants must file an undertaking not to interfere with the case, as well as attend trial in order not to cause delay.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Soyele. Thank you for watching, and see you next week.